Welcome, everyone, and thanks for joining us today. I'm so glad to have you all with us for a discussion on some contemporary challenges to the rule of law and the separation of powers, and a consideration of what those challenges mean for the future of liberal democracies. My name is Keith Cherry. I use he, him pronouns, and I'll be your moderator today. And I'd like to start by thanking the Center for Constitutional Studies at the University of Alberta for hosting this event and bringing us all together. And I'd like to acknowledge with respect that the center is on Treaty 6 territory, and that these are lands which are traditionally used and governed by the Cree, Nakota Sioux, Dene, Blackfoot, and Métis peoples. And I'd like to recognize Treaty 6 itself and all of the many benefits that it bestows on settler peoples and on the Center for Constitutional Studies. And I'd like to acknowledge that that treaty also recognizes and affirms Indigenous jurisdiction on these lands, which continues to this day. Given that many of us are joining remotely, I'd also like to take a moment to acknowledge that I personally am joining from unceded Lekwungen and Wasanich territories, which are Douglas Treaty territory. And I'd like to express my gratitude for the benefits of that treaty and my respect for the ongoing authority of the Lekwungen and Wasanich peoples on these lands and waters. I know that many of you are also joining from unceded or treaty territories across Turtle Island and around the world. I'd like to acknowledge that as well. And last, given that we will be discussing the rule of law today, I think it's only appropriate to acknowledge that settler governments continue to dishonor their treaties by denying Indigenous jurisdiction and sovereignty, and that as with any threat to the rule of law, this should be grave concern to all of us who are interested in the future of democracy in settler states. So with that, I'd just like to discuss a few housekeeping matters, and then I'll introduce our panelists and we can begin our discussion. First, you'll notice that the chat function has been disabled, but that there is a Q&A button at the bottom of your screen, and we will be reserving some time for audience questions after our panel discussion. So please feel free to put your questions into that Q&A box. I also want to note that this event is being recorded and will be available later on our website and on YouTube. And at the end of our discussion, you'll see a pop-up box prompting you to a feedback form. And we really do take that feedback seriously, so I strongly encourage you to share your thoughts about the day's event. All right, let me now introduce our panelists today. Our first panelist is Arjun Tremblay, who is an assistant professor at the University of Regina, specializing in comparative politics. And joining him, we have Mary Liston, an associate professor at the Allard School of Law, specializing in public, administrative, and constitutional law, as well as Hilary Nye, an assistant professor in the Faculty of Law at the University of Alberta, specializing in legal theory and the rule of law. Jan Allard Tremblay, who's an assistant professor at McGill, focusing on political theory and decolonization. And finally, we're joined by Professor Jacob Levy himself, who is the Tomlinson Professor of Political Theory at McGill. And I'll turn the discussion over to our panelists in just a moment. But first, I have the daunting and unenviable task of attempting to briefly recap some of the themes that Professor Levy put forward for our consideration in his McDonald lecture. Now, I only have a few minutes, so obviously I won't be able to do justice to his rich talk, but I hope that I can at least provide a primer for the audience, and I'm certain that Jacob and the other panelists will flesh out these themes in more nuance and detail. So, Levy's McDonald lecture really centers the idea of the rule of law and the separation of powers as a hallmark of constitutionalism. Levy tells us that in order for a system to be called constitutional, it needs, at the minimum, an independent judiciary, some sort of separation between the executive and the judicial functions, because this guarantees the rule of law. And without this, we can't consider a system to be properly constitutional. So Levy places the rule of law and the separation of powers that guarantees it at the center of constitutionalism and offers us a genealogy of the separation of powers and an account of some of the challenges that it faces today. And interestingly, the genealogy begins in ancient Greece with the contests in the ancient Greek world between aristocrats and democrats and absolutists, partisans of the rule by the few, the rule by the many, or the rule by the one. And Aristotle, writing in reaction to these struggles between different forms of rule, introduces the idea of a mixed constitution, a constitution which combines elements of the rule of the one, the rule of the few, and the rule of the many. And the mixed constitution arises as a sort of pragmatic solution to social division, as a way to unite various classes in society and pool their powers together by giving them each a stake in the governance of the polity. And Levy shows how this practice arises again and again in European history, from the Roman Constitution to later European kingdoms. People keep reinventing this idea of a mixed constitution as a natural solution to social divisions within their society. But at this point, the mixed constitution is really seen as a means to pool powers together rather than a way to separate them out. And for that reason, the mixed constitution isn't necessarily intrinsically tied to the rule of law, because it doesn't necessarily guarantee a separation between executive and judicial powers. But this begins to change with Montesquieu and his creative reinterpretation of the British Constitution, which he reads through the concept of mixed government. And Montesquieu marries that concern with mixed government with a concern for the rule of law. And he maps the different social classes of the mixed constitution, the one, the few, and the many, onto the different functions of contemporary government. The executive, which is dominated by the one, the legislature, which is dominated by the many, and the judiciary, which is dominated by the few. And in so doing, Montesquieu helps recast the idea of the mixed constitution not as a pooling of powers, but as a separation of powers, a separation of governmental functions, and crucially, one which ensures an independent judiciary and thus the rule of law as we understand it today. But Levy calls our attention to at least two contemporary threats to this separation of powers and the rule of law, which it guarantees. And the first comes from party politics. Because, of course, in a partisan political system, it's possible for multiple branches of government to be controlled by the same party, in which case the branches may stop checking each other effectively. And this puts the rule of law at risk. But even when the different branches of government are controlled by different parties, party politics still threatens to undermine the separation of powers in a different way. Because when an opposition party exercises its powers to check another branch of government, the people tend to perceive that as partisan politics, as a maneuver for electoral advantage, rather than a principled defense of important constitutional principles. So party politics put us in a position where we either have one party controlling multiple branches, in which case the separation of powers may break down, or we have different parties controlling different branches, in which case the use of checks and balances can be easily cast as illegitimate. Either way, political parties present a challenge to the way we understand the separation of powers, and through it, the rule of law. And the second threat that our attention is drawn to is the threat of nationalist populism, which harkens back to this idea of a pooling of powers, a combining of social classes, which has left our political imaginary with a concept of the people as a unified, undifferentiated body. And this idea can be problematic because if the executive claims to be a representative of the undifferentiated people, then it creates an opening for the executive to present any checks on its own behavior as checks on the people themselves, as barriers to the will of the people. And so once again, the perceived legitimacy of checks and balances can be thrown into question through a populist nationalist discourse in the hands of a power-hungry executive. And as a result of these two threats, we see an increasingly executive style of government across both parliamentary and presidential systems around the world. An executive which is increasingly less constrained, increasingly lawless, and increasingly able and willing to use the tools of government against its opponents. And all of this has the potential to undercut the separation of powers, and through it, the rule of law, and through it, to undermine the very constitutional character of our democracies. And this is the conjunction that we've gathered together to discuss today. And with that, I will turn the discussion over to our panelists. Each panelist will have 20 minutes to lead a discussion on some themes that they have selected. And Arjun Tremblay will start us off. So I'll pass it over to you, Arjun.
Thank you, Keith. And before beginning, I'd like to take the opportunity to say, as a representative of the University of Regina, I'd like to acknowledge that the University of Regina is on Treaty 4 lands with a presence in Treaty 6. I'd also like to take the opportunity to thank Keith Cherry, Patricia Paradis, and Josh Nichols for inviting me to participate in this wonderful panel, and also to thank Professor Levy for his highly informative and very timely talk and for joining us today. The two themes that I've identified for discussion with Professor Levy and with my co-panelists deal with the separation of powers as both an desired outcome and as a cause in and of itself. And so I'm going to kind of organize my two themes along this. And I want to start with discussing the separation of powers as an outcome. So in Professor Levy's talk and elsewhere where he discusses the separation of power, he points to the inextricable link between the separation of powers and constitutional democracy, and also to the growing ineffectiveness of the separation of powers in constraining executive power, and as well as to the executive branch's usurpation of legislative authority, all of which might be leading to a constitutional crisis. Taken together, all of this suggests is that in order to avert a constitutional crisis, we should see that the separation of powers is protected, preserved, and in some way revitalized. In his talk, Professor Levy also identifies a number of factors that could be seen as important roadblocks to protecting, preserving, and revitalizing the separation of powers, and in their absence, allowing a constitutional, as a result of these roadblocks, preventing the aversion of a constitutional crisis. So some of these roadblocks that he identifies are political parties, partisanship, which under a unified government scramble the logic of the separation of powers, the appearance that legislative tools of investigation and impeachment are purely partisan under a divided government, an overall loss of faith in democratic institutions, a decline in democratic norms, and nationalist and populist ideology, which legitimizes executive authority to act on behalf of an undifferentiated, unified people. So this raises a few, I guess I could call them unfair questions. And to say, in light of these roadblocks, my question really is how can the separation of powers be protected, preserved, or revitalized? Or in other words, is there a roadmap, institutional or other, to protecting and preserving the separation of powers? And if so, what would this roadmap look like? So that's the first one, dealing with the separation of powers as a desired outcome, or some revitalization or reinvigoration of the separation of powers as a desired outcome. The second theme for discussion is thinking about the separation of powers as a cause. And so the second theme relates to the separation of powers as a possible remedy to democratic backsliding, de-democratization, and the decline of democratic norms, both within the United States and perhaps from a broader comparative perspective. One of my questions here is whether the revitalization of the separation of powers is or could be seen as the critical factor to reversing these trends that I've just identified: de-democratization, democratic backsliding, in the United States, but perhaps even in parliamentary systems where there is somewhat of a separation of powers between the fused executive, legislative on the one hand and the judicial branch on the other hand. I'm also interested in hearing perspectives on how the separation of powers can play a role, if at all, in dealing with other threats to democratic institutions and norms, such as voter disenfranchisement, the propagation of lies by elected representatives, which perhaps we could diplomatically call post-truths, and right-wing populism. And kind of more generally, what I'm here is kind of curious to hear is whether the separation of powers in and of itself can engender the democratic reforms. And if not, what additional factors might be needed to preserve constitutional democracy. So to sum all of this up, when we're thinking about the separation of powers as a cause, I guess really my question is saying, when we think about democracy and preserving democracy in the 21st century, how important is the separation of powers in preserving democracy? And is it a cure-all? What else might it need to help reverse certain de-democratization trends that we're now observing? And those are the two themes for discussion that I'm throwing out to my colleagues.
Jan, please go ahead.
Thank you. I will be brief because I think that the themes I am suggesting to discuss a bit later on connect with this question of the separation of power as an effect on outcome. What solution can we have in order to ensure that this is still realized despite the roadblocks that are discussed? But I think that there might be something to reflect on in terms of thinking about the separation of power, not so much in terms of a division of power that can stop one another, but in terms of various, well, we could say interest groups or groups that can distrust one another so as to block the abuse of power. That would take us away from the rule of law. And I think that's something I'll discuss a bit later, but that might be one way in which we can think of preserving democracy, as you note at the end.
I think I'm going to echo what Jan just did, which is to suggest where there might be some links to some of the themes that I have proposed. And I guess my main inquiry in the two themes that I've selected is your connecting it with your second theme about what the separation of powers itself can do in the service of democracy and the rule of law, given our current state of affairs. And I guess one of the questions I'm interested in exploring, and really have directly posed to Jacob, is this idea of the role of the courts themselves as a site of construction for the separation of powers. And I know this connects up with Hillary's theme too on the rule of law. And so how these different institutions can function differently, but often not just competitively, but collaboratively, cooperatively in the service of these overarching values that they are constitutionally obliged to uphold. And so I'm going to be interested in the discussion that Arjun, you've posed in this. I'm thinking about, well, where are we looking for remedies, really?
Yeah, so I'll just jump in, kind of echoing some of what's been said, and on the question of what can the separation of powers do sort of on its own or in combination with other things. And I wanted to pick up on one of the roadblocks that Arjun mentioned to do with partisanship, right? So there's this worry about increasing partisanship causing problems for the separation of powers. And I guess what I thought I might turn our attention to is the question of whether that partisanship, do we think it's reflected the same in all three branches? If there's partisanship in all the branches, then we might have a worry about separation of powers because there's not going to be enough differentiation. But if it's so if that's the case, then one of our ways forward might be thinking about how to make each branch less partisan. But if we think so, an alternative way to go then would be to say, well, partisanship in the structure of the branches isn't going away, so let's work on the party side of it rather than the branches side of it. So is there something we can do to the parties to make more party competition, or something that would in some way lessen the partisanship?
Thanks, everyone. That's a fantastic start. I know I'm not the only one who's curious, though, what Professor Levy might have to say about this opening that Arjun has provided us with.
Oh, I wasn't sure about throwing my 2 cents in after each comment, and I don't want to have too much just Q&A with me. I will say, for whatever it's worth, I don't believe in cure-alls, and I believe in a world that has lots of problems to solve, not one problem to solve. Even within the confines of my talk, I think that nationalist populist ideology and the orientation toward unity in politics and political decision-making is meaningfully a separate problem. It's a problem that interacts with the institutional fragility of the separation of powers and magnifies it. But I don't think that the connection is of the sort that if we pull this lever over here and fix the separation of powers, which I don't know how to do, or I would have said something about that, that would go upstream and also fix this ideological problem about the temptation to too much unity and the aspiration to too much nationalism in political life. I think that if there are solutions to be found, they're going to be multiple, and ideological and institutional problems can interact without it being the case that they will be solved in just the same way.
I mean, I think, thanks everyone. I've just been taking notes of everything that you've been saying here. And I don't think I have much to add beyond this. And but what I'm glad to see is that that there's some links between the themes that I've identified and what my co-panelists will be bringing up in their discussions too. And I think maybe just to kind of conclude my part of this panel is just to say that I think that's an indication of how stimulating this talk was, and also the fact that political theorists and legal scholars and a comparative political scientist can somehow have a coherent talk about this. And so thank you all for your comments and feedback. They really got kind of, I'll be absorbing them as we're talking and as I'm listening to your themes too, and I hope to be able to contribute to what you have to, the themes that you have to identify to this talk. So that's all I've got to really say at this juncture. Thanks, Keith.
Before we completely close out of your topic, I guess what you just said about constructive discussion between a political scientist and a legal theorist and a political theorist, I guess I kind of wanted to hear a little more from you on, because you do come from that more political science background. I often find myself as a theorist kind of like I can only get so far with the theory, and then there's empirical tools that I lack in terms of figuring out what would come next, what would be a practical solution. So I just wanted to know if you had anything to add on that.
So great, thanks Hillary for asking that question. And actually the way I think the way I articulated the themes, that's kind of my tell as how I'm thinking as a comparative political scientist, is I'm thinking in terms of cause and effect and relationships between variables and, you know, independent and dependent variables, and what is the intervening variable. So this is what I'm thinking. So the question, the first question about thinking about the separation of powers as an outcome. So there I'm thinking about it as the dependent variable, as something, the outcome that you want to achieve, right? And this is the puzzle-based methodology that we have, is that you have an outcome that you want to achieve, but the obstacles seem almost insurmountable. So how do you find a way kind of around that? And I think that's one thing that comparative political science can help bring to complement certain of these discussions, is that a kind of understanding of what, as I put it, roadblocks are, institutional roadblocks are to achieving certain outcomes, and then thinking in terms of the ways around that. So a lot of my research now begins with identifying institutional roadblocks to achieving desired outcomes. So I benefit from a lot of the normative, from the work of normative political theorists too, who are very great at articulating, what it is that the good life is and what is it the outcome that we should desire. I think what comparative political scientists can bring in is saying, what are the obstacles to achieving these outcomes? And that's part of realizing a desired outcome, is also knowing what are the impediments to getting to that. And then thinking about the separation of powers as a cause, there's where I'm switching gears and thinking about it as the quote unquote independent variable. And as Professor Levy said, and this is as a comparative political scientist, there's no monocausal relationships, right? There's always a number of variables that are at work that will lead to the outcome. So absolutely, the separation of powers is not a cure-all. And I guess I maybe tried to phrase it in a somewhat provocative fashion. But yes, I mean, a comparative political scientist would certainly agree, is that there are those other kinds of variables that are there. And what I'm kind of curious about this too is exporting the idea of the separation of powers and the ideals that Professor Levy brought up in his talk, and saying, how can those ideals and those institutional formulations serve other kind of democratic contexts? I know that this is a long kind of ongoing discussion, particularly for in the research, some of the research that I do on federalism and moving beyond the US model of federalism towards notions of multinational federalism. But that also suggests is that the US model of federalism has been preeminent for such a long time, and that other democracies have been inspired to it. So this is kind of what I'm thinking, is that, the substance, if you can have a revitalized separation of powers, how can we extract the substance from that and see how it could maybe be an important cause among others in reversing some of these democratic trends. So that's the spiel for my subfield and my discipline. But that's really, I think, what it is that how comparative political scientist says what we can really do is benefit from the normative theory to understand what the goal is, what the outcome is. And I think one thing that comparative political science can bring to the discussion is understanding roadblocks and obstacles to achieving that outcome, right? And taken together, that helps us to move closer to the desired outcome. So thank you, Hillary, for setting me up for that pitch. Appreciate it.
Oh, thank you. And that was really, really fantastic, especially sort of thinking about how it goes both ways, right? So as a theorist, it really helps me to be able to go and look at someone who's actually done research and then bring those things together. So thanks.
Mary, did I see you raising a hand there as well?
I did. Well, I sort of wanted to pick up with the exchange between Hillary and Arjun, and sort of, again, thinking about where we're going in this talk around the rule of law and the substantive content of the separation of powers. And I guess, so Arjun, thinking about your cause and effect, it reminded me of, I don't want to go down the path of despair too early in this session, but I'm going to, I guess. Which is, the whole issue of Supreme Court appointments is such an interesting example of this, that when we look at Jacob's talk and his presentation of Montesquieu's philosophy as putting the judiciary at the center, at the heart of a constitutional polity, later becoming a constitutional democracy. And that's the independence of the courts and the role morality of judges in their office and their fidelity to their duties and function. And so one of the most surprising things, I think, for people outside of the US is when you read a Supreme Court decision from the US Supreme Court and how that's all, well, it hasn't all, but how that has also deteriorated as a result of this partisanship that is plaguing so many political communities, and in which Canada, I think we're quite afraid, is developing as well. So I hope we can return to Canada in comparative context. And how, you know, the Supreme Court justices don't talk to each other the way they used to anymore in their judgments, which to me is symptomatic of both the effect on the judicial institution, and it's also causal because it's feeding back into the growth of partisanship. And so I think that's an interesting example that touches on all of our themes.
And maybe if I could just add one thing is to bring Mary and Hillary's kind of a couple of their points together too, is both centering on the role of the courts and the whether partisanship. I really liked Hillary's point too as to whether partisanship infiltrates the branches in the same kind of particular way. And I can't think of research that I've seen so far that really addresses that question, but that could just more speak to my ignorance than anything else. And I think, you know, I think there's a connection between what Mary just said and Hillary's point too, about the lack of communication amongst justices. Is that an indication of, in some way, shape, or another, of strong partisan beliefs or something else at work within this process? So I think that I think is something that I hadn't considered, and I think this is a very interesting point as to how partisanship affects the branches. So this is another thing for comparative political science. You're trained to think in terms of variance, and then the question is does partisanship affect the branches in the same way or to different degrees? And so I thank you both for kind of bringing this to my attention and perhaps opening up a new avenue of inquiry.
Yeah, I really appreciate that turn to a comparative and more empirical take on the issue as well. And in fact, it has me wondering, are there studies done comparatively looking at different countries and the degree to which they experience this sort of hyperpartisan moment that so many seem to be in? And are there exemplars that are studied in the literature, places which seem to have escaped this problem or to have developed ways to deal with it?
I think that's a question for further research. And I mean, I can say that sort of more broadly, and bringing it back to Professor Levy's point about the interconnectedness between institutions and ideology, and right now, so a lot of my research now is veering in towards looking at right-wing populism and issues of diversity and the politics of difference and right-wing populism. And within that context, there are studies that look at, so first of all, is getting a handle on these terms. Ideology, populism, what are they exactly? How do we observe their manifestations? Right. I know you were talking about partisanship, and I'm kind of shifting gears a little bit. You know, because partisanship, I tend to associate that more kind of within the discourse on American politics, and I'm thinking about phenomena that we can look at kind of more broadly in terms of from a comparative lens. But I think one of the big challenges that we face right now is in the empirical part of political science is what we'd say operationalizing our dependent variable. It's getting an understanding of what these terms are, what their manifestations are, so we can actually find a way of observing them as accurately as possible, and then working our way back to any kind of explanation. So, you know, whether this is a work that can be achieved within one lifetime or several ones, don't really know at this point. But that's the kind of the key thing. So Keith, so to answer kind of your question is saying, part of the difficulty in understanding the different kind of manifestations, getting a keen sense of what these concepts are and how we can observe them in different contexts.
And I'd add that in any inquiry like that, we'd want to keep the ideas of polarization and partisanship at least partly distinct. Sometimes polarization is only partisan polarization. That is to say, the parties acquire more and more negative and hostile attitudes toward one another. But you can have ideological polarization, either in the populace or among officials, in a way that doesn't map neatly onto partisanship. Sometimes, and I think this is some of what's happened in a number of Western democracies since 2010 or so, sometimes you get increasing polarization and weakening partisanship, such that the polarization, at least in the electorate, will mean more and more people who are disengaged from any traditional political party, adopting more and more extreme positions, and then tempting the parties to chase those disaffected but extreme voters. But that's polarization in the driver's seat, not partisanship in the driver's seat. Whereas when you study something like what's happening when people in the legislature stop speaking to one another and stop working together, that's a partisanship dynamic that's, I think, importantly distinct.
Yeah, I appreciate that distinction very much. And I'm pleased to see that we're already going some distance towards clarifying the terms we need to operationalize and understand in order to explore this question more thoroughly.
I maybe have a follow-up question to Professor Levy based on this inverse relationship that can exist between polarization and partisanship. And just thinking about, and if I understand the argument in your talk is, I mean, I know political parties and partisanship are different things, but would a decline in partisanship be a way, if we can maybe just dissociate it for a second from the idea of polarization, would a decline of partisanship be a way of, if I understand it, of kind of protecting the ideals of the separation of power? Is that it? And how would that, in the age of polarization, is that even feasible?
I try to avoid constantly adverting to US cases. For this one, it's hard for me to avoid because I don't have enough comparative cases in my head for the change over time. The long era of weak partisanship and weak parties, relatively weak elite parties, because so ideologically disparate parties in the US, I think did paper over the cracks I'm talking about in the separation of powers. There was enough status-oriented concern with office on the part of powerful enough people in Congress, whether they were part of the president's party or not, that there was some capacity of Congress in a bipartisan way to act as at least sometimes a kind of legalistic check on the presidency, in a way that more or less just crumbled after the parties became so coherent starting in about 1994. That said, that era of ideologically messy partisanship and of kind of high bipartisan comity in Congress was an institution of Jim Crow. I mean, the reason why the parties had that kind of relationship in the United States was because of the alliance of Southern white Jim Crow Democrats with Northern liberal Democrats for partisan purposes, but with conservative Republicans for certain kinds of institutional structural purposes. That's not a bell we want to unring. That was a deeply unattractive partisan history that gets romanticized a lot in tales of, gee, in Washington in the old days, we were nice to each other. Well, what that means is we white members of Congress were nicer to each other on the back of a systematic disenfranchisement of African Americans and an ideological disguising of Jim Crow behind this funny fact that the Democratic Party had this 2 regions and 2 ideologies structure to it. So you get a little bit more separation of powers at a very high cost somewhere else in the system. I also think that weak parties are a democratic problem in their own right. And so again, that's not something where I would want to say, because it looked like you got a little bit better separation of powers under the old party system, therefore we should have something like the old party system. I don't know what the way forward is, but I think the way forward goes through vitalized parties, not an attempt to undo that. Was that at least in the neighborhood of the question you were asking?
That's a much better answer than the question that was asked. I appreciate it.
Fantastic. And with that, Hillary, would you like to introduce some themes for us to discuss?
Yeah, absolutely. So I think this will nicely follow on from some of the discussion we've already been having, but what I want to focus on is specifically the connection between the separation of powers and the rule of law. So I think the idea of the rule of law put forward in the talk was really focused on procedural limits, so ideas about due process, impartiality, the idea that the judiciary needs to be independent and not interfered with, so that it can make the right decisions. So I think those are all really important threads in the rule of law literature, but there's a kind of separate and potentially opposed tension or opposed thread within the rule of law literature that focuses more on kind of substantive outcomes and says rule of law really requires that judges decide according to the rights that people genuinely have, or that there be a check not just on the process but on the substance, so that judges need to be attentive to are they upholding something that's fundamentally unjust, and there's some scope under these types of views for judges to intervene in substantive matters, not just process. And so I guess what I wanted to ask is really what would happen to the idea of the separation of powers if we incorporate that more substantive vision of the rule of law. So if we think of the judge's role not just as protecting the processes of impartial treatment, but of providing limits on the actual substance of the law. If that's the case, then I wonder whether that dissolves some of the separation, because now the judge is involved in something that maybe we've previously taken to be the role of the legislature in setting policy. Now the judge is sort of stepping into that realm. So perhaps the separation kind of dissolves to some extent. And I think, so I partly wanted to ask, my first kind of question is, what do people think about that kind of vision of the rule of law and its compatibility with separation of powers? And then my second and kind of related theme is to do with checks and balances, because I think that version of the separation of powers that I've just outlined, or sorry, of the rule of law that I've just outlined, kind of is closer to a checks and balances model. It says, well, actually, it's part of the role of each branch, not just to stay separated, but to get involved with the other branches by checking them. And so I think sometimes checks and balances are sort of equated with the separation of powers, but in some ways they're at odds, because for them to be wholly separate, there'd be no scope to check them, right? So I guess I wanted to discuss that idea of checks and balances and sort of how far can a branch go in checking the power of another branch without kind of crossing too far and potentially muddying or undermining the idea of separation of powers. I guess one thing I'll just sort of add to that is picking up on Mary's point a moment ago about role morality. So you were talking about fidelity to duty and this idea of the judge's role. And so maybe a different way to put my question would sort of be to say, well, what is our idea of role morality for judges? Do we expect them to stick to the text and focus on procedure, or do we expect them to be in part sort of protectors of justice?
I'll say one thing to start this part. And that's here, I think there's going to be a lot of reasonable cross-country variation. While I think there are structural features about judicial independence and procedural rule of law that really are necessary components of anything like constitutional democracy or constitutional government. The variation in how substantive judicial authority can be, and in particular variation in how much strong form judicial review over substantive areas of legislation there is, that is to say, moments when judges are going to act like Dworkinian, Herculean adjudicators of justice. There simply is a lot of cross-national variation among constitutional democracies, and that there's variation doesn't mean that each of us might not have a view as to which is better or worse, but I'd be resistant to mapping that onto saying there's more or less effective separation of powers in those different countries. Different constitutions have different amounts of substantive content built into their bills of rights. Different constitutions have different amount of strong and weak form balances about judicial review. So that's that. I guess that's my starting answer to that question.
I love this question. I guess I think about this quite a lot in my job, and in particular in my area of law that I teach every year, administrative law, which is a form of constitutional law, but we don't talk about it that way in Canada, where the chief function of our courts is to review executive action. And so one story there in relation to the substantive content of the rule of law that I think is interesting and that we share with other common law countries. I don't know about I would suspect of even civilian countries too, but I don't want to put that out there as an empirical claim. But anyway, the decline of the decline of free prerogative power in the executive branch. That historically it has been increasingly tamed through statutes. So, in a parliamentary democracy, that prerogative power is taken away and given back through a statute to officers in the executive branch of government, the many types, and that's constrained, but they still have large scope of powers, often discretionary powers, and that's leading to one of my questions, which is we've seen the courts winnowing down the areas where the prerogative power has been considered traditionally not justiciable, and then they often are winnowing or shaping the contours of the scope of those kinds of powers, discretionary powers as well as traditional prerogative powers. And so I think that's where you see this, it's both procedural and substantive for the rule of law. And I guess one of my examples, but not necessarily in the service of the rule of law, it's back to our constitutional democracy discussion where we started. And I guess my example for us maybe to think about either here or later on is the Miller 2 case in the UK, the Brexit case, where the UK Supreme Court found that Boris Johnson, the Prime Minister's advice to the Queen was unlawful. That's unprecedented. It really is. It's a game changer for every system that's like the UK. It is an active court, but it wasn't. It was in the service of Parliament. And that is what is also very interesting about it. And so Hillary, going back to that complicates the separation of powers. One might disapprove of what the Supreme Court did, on other grounds, but one may approve of it if one wants to see parliamentary powers and that function bolstered. So I've been thinking about that a lot in terms of how executive power has both grown, which Jacob has talked about, and again, what are these potential possible ways we can either check it or constrain it?
Can I speak, Keith? Yes, okay, thanks. I was waiting for the authorization from the chair. So on that question, I think I would doubt that seeing the role of justices as being more substantive in terms of the rule of law would really address the issue that have been raised by Professor Levy, because to a large extent, the courts, the currency of the courts is their appearance of impartiality or legitimacy. So once we enter into the realm of hyper partisanship, the appeal to a substantive truth or substantive justice will not resolve the issue, right? It will still appear as a partisan positioning. So in that respect, I'm unsure that understanding or going towards a more substantive understanding of the rule of law would be useful in addressing the concern or the crisis of constitutional democracy as framed by Professor Levy.
Yeah, that's a really interesting point, and I think it connects to something we'll get to in your theme too, to do with trust and distrust, about sort of which branches of government do we or don't we trust, but I don't want to get ahead of ourselves.
Maybe if I could connect that with that, I mean, we'll talk about it later, but the issue is that this seems to imply that we should trust the court, but we're already distrusting it, or we're already distrusting certain branches. So how do we ensure that we can trust it to be checking the government for the right reason?
Yeah, I think that's a really helpful framework to thinking about it, which in a way circles us right back to Arjun's original point about the role of actual political scientists kind of coming in to inform our theory. So not just thinking about what would be ideal, it might be ideal to have a more justice-facing, justice-oriented kind of court, but we have to think about that question in the context of actual studies of people and how they perceive the courts, how they interact with the courts, what the ideas of partisanship are that circulate in the population.
Maybe just to add something here. So thank you, Hillary, for giving me a segue just into this discussion. Just kind of, I found your framing of the distinction between separation of power and checks and balances really fascinating. And I love your question about where you say, how far can a branch go in checking the power without muddying the required separation of powers? I think this is a fascinating question. I just want to kind of maybe add a complication to it. If we kind of bring one or two elements from Professor Levy's talk into it, talking about really the increase in executive authority over time. And I think one of the complication is when we're asking that question is that there already seems to be an imbalance in power across the branches of government and an increasing imbalance. And maybe can we also ask the question of saying, how can, it's not, how far can a branch go, but maybe some branches have their power has to be increased to become more effective checks on other branches, and which we've seen in the current American administration. It seems like the legislative branch has not been an effective check on executive power whatsoever. And so that's just a kind of a complication. It was really just kind of, I was thinking about your question. I said, okay, you know, but so maybe can we also think about it that way? Is that are we also talking about a situation where other branches, or I'd say particularly the legislative branch of government, has to be empowered at this moment? And if so, how do you do that?
I didn't want to speak too much, so I was giving a little bit of space to other people, but it is my theme. So thanks for that. I think that's a really important insight. This is all really good food for thought in terms of, I don't know, the puzzle about checking and balancing to me is a really interesting one. And what you were saying about sort of, well, maybe there is no sort of arbitrary amount of power that they should have, that we need to stick to the amount of power they already exercise, right? We might, as you said, think about expanding it greatly. So to me, that sort of suggests almost rethinking from the ground exactly what amount of power the different branches wield. So why think that they operate in the way that they do, except for historical accident? So what would be the sort of foundational justification for the particular amount of power that a particular branch holds?
And I think that just to follow up on that, I mean, I'm kind of out of my depth as a political theorist, but you know, I kind of maybe throw a political theory question out there, and it was something that I was thinking really. It's kind of one of the big questions that I had, sort of following up with what Hillary said, and I think it leads to this, is thinking about, you know, when we think about the separation of powers in the United States, we think about its foundational roots, it's the philosophies that are undergirding it in the late 18th century, and saying, well, I think exactly what you just said, Hillary, what if we were to reimagine it now, right, in a different context, with the benefit of, you know, a couple of hundred years of hindsight, and, you know, kind of connecting this with Professor Levy's point that we've just seen if I remember correctly, you were saying you've seen a decline in loyalty to office or to branch, and now an increasing loyalty to party, which kind of breaks down the ideals of the separation of power. So with that, and when we've seen the branches being imbalanced in power, so if we were to, so as I say, this is kind of my brief foray into political theory, is saying, you know, if we were to reimagine it, can that be done, and what would it look like? Would there be a different kind of reimagining of the separation of powers now, and what would that entail? What are the key problems that are identified from a couple hundred years ago, and what are new solutions that could be provided?
Yeah, I think this is a fascinating take on, or idea, to reimagine the separation of powers in a, not as kind of a static institutional setup, but as a responsive, adaptive maneuver. That the power relations between branches will fluctuate over time. So is what we need really a balance of powers between the branches, and that will require empowering and disempowering different branches differently in different political contexts and different constitutional cultures. But perhaps the aim to have in mind is a balance of power in the sense that's sometimes used in international relations theory, but transposed onto a domestic context.
Yeah, I might just sort of invite Jacob to jump in about the historical aspect, because I found that talk of that aspect of your talk so fascinating. And I'm not a historian, but I kind of wonder what both philosophers and political scientists can draw from history, or what you think, to what extent is it our job to sort of learn from history, and what can we draw from it in these types of discussions?
Okay, I wanted to say something about the going forward question, and then I'll say something about the looking backward question. My own sense about what we've learned and what we would do differently on the basis of what we've learned is actually not to make it more like pure check and balance, pure countervalence. It's rather to notice all the different places in government where we need to have multi-step articulated processes that have this relationship of rule articulation, rule application. There are many more sites like that in government than simply what was imagined in the 18th century as legislature as a body, executive as a body, or even worse, a person, and judiciary as a body. I think across constitutional democracies is a real challenge about managing the investigative and prosecutorial functions of the executive within the executive. The problem of what an attorney general is, or of what federal investigative police are in their relationship to the political executive, and how to think about their quasi-independence, but also need for accountability and responsibility. We would not rebuild the separation of powers in a way that just subsumes the police and the prosecutors and the attorney general who is in charge of them all under a partisan elected chief executive. What it is that we would do, I don't quite know. But I think that needs to be the kind of place where we invest attention going forward. Something similar about civilian control of the military. We understand that on the one hand, it's absolutely vital in constitutional democracies that the military not be an autonomous political actor. We also understand that the military has an obligation to obey the law and the system that supersedes the obligation to obey the elected political executive if those come into really deep fundamental conflict. That is a separation of powers like problem that on the classical 18th century model just looks like an intra-executive problem. But it's not. It's a problem about the relationship of general rules to particular moments of application and the conflicts of interest that arise. That makes it squarely a separation of powers like problem. And so what I'd really like to see going forward is an investment of energy, not in how to get more things just bumping into each other, but how to think about constitutions that have separation of powers like moments in those new potential crisis points that hadn't been imagined by Madison or Montesquieu as having the kind of political importance they have. The value of history. And I mean, I'm not a historian, but the kind of political theorist I am keeps one eye on history a lot of the time. And my example within the confines of this material for the value of that is the jump from Montesquieu to the Federalist. The jump from the separation of powers imagined as being self-stabilizing because the different powers vested in different social classes with their own really strong independent power bases, to the Democratic Republican separation of powers, and just the hope on Madison and Hamilton's part that pride of office could completely substitute for the sense of class distinction that the standoffs among aristocracy, monarchy, and populace provided. I think reading the separation of powers entirely through the lens of the Federalist Papers and the American founding, which is a really common thing to do even in non-presidential systems, has obscured that. It's really obscured it for a long time. And it not only means people misread Montesquieu, it means people miss a way that fragility got introduced into the system early on. And so what I hope is looking at that, remembering that shift from something that was supposed to be socially self-stabilizing to something that rested on a much more fragile social foundation, can open lines of inquiry to us empirically as well as normatively. I mean this to be a live research agenda in political science as well as political theory and constitutional law. But to notice paths not taken and to realize that the path that did end up getting taken might not have all of the virtues and strengths that were imagined for it. That's not a complete answer, but in this context, it's the kind of thing that I'm trying to do, to get us to take what we have less for granted. In this case, to take the American-style Democratic Republican, all drawn from the same social material, separation of powers, less for granted by noticing a foregone alternative.
I wanted to pick up where both of you were talking about other sites. And one thing I think about, again, in the growth of modern governments. And so I don't want to say there are strengths and weaknesses, pros and cons to some developments in the modern state. But one of them has been, in some sense, the executive divided against itself, partly through the growth of different watchdog and oversight bodies. And that gets duplicated in a number of ways. It's a bit like a fractal, really. And I'm thinking of something like the great amount of independence that our chief electoral officer has over the federal election system, which is crucial. I'm thinking of something like an information commissioner, who again has a level of independence, so they're part of the executive branch, but they're there to make sure that information is made as accessible and transparent and democratically available as possible. Some things like legislative officers who are straddling the executive and the legislature. They're the agents of the legislature, but they're overseeing the executive. And I guess I'm thinking of the Auditor General in Ontario right now. And that issue raises all of these other concerns about, well, who's serving who and who has the right for the right purposes, right? Are you really serving some other interest against the government of the day, for example? But I just want to point out that, as part of this genealogy, we have an account of there have been other developments. Again, they're not without their own problems, but they are adding to this really varied and rich conception of the separation of powers, I think, in the service of all of these ideals.
Thank you, Mary, for that very eloquent and perfect transition point, actually, I think, into Jan's set of themes, building off of your point about watchdogs and our trust in their motives in the checks that they're exercising, I think leads us very nicely into the next set of discussion.
Thanks. So I have two themes. The first one is harnessing distrust and institutional incentives. And it does connect with a few things we were just discussing. So, in his talk, Professor Levy raises the issue of political parties attracting loyalties across institutional boundaries. By attracting these loyalties across institutional boundaries, this undermines the institutional incentive, or as Professor Levy just calls it, the pride of office, to uphold the separation of power. So to summarize briefly, we could see the historical separation of power between the House of Commons, the House of Lords, and the Crown, and between the monarchy and the parliaments, for instance, as institutional arrangements that harness distrust that is already present. The distrust of these distinct classes for one another, or these distinct estates for one another. But as Professor Levy explains, there was no monarchy, no nobility in America on which we could rest the separation of power. So then they rely on the pride of office. But in this context, the separation of power between the executive, the legislative, and the judiciary is meant to create this institutional incentive to distrust the other branches. But as explained by Professor Levy, these institutional incentives are being eroded by the influence of political parties. But so rather than creating institutional incentive to distrust, could we envision the task of institutional design in our contemporary societies to be one of harnessing distrust rather than creating it. For one thing, we keep relying on political divisions to which people generally have no attachments, such as ridings or counties. But we do observe a significant political division between cities and rural areas. So I would like to think with you about the relevance of finding avenues to harness existing political divisions in a productive way. And this connects with my second theme, which is the myth of the unified, undifferentiated people. And if you know my work, that's obviously where I would go. As discussed by Professor Levy, the idea of the people reinforces the pretensions of the executive that no one should stand in its way. But beyond this breakdown of the separation of power, I do think it's important to consider how the idea of the united people as a working illusion of our politics relies on the erasure of significant political divisions that could help to ensure the rule of law. More specifically, in this context, I'm referring to the erasure of indigenous peoples, colonized peoples, even racialized peoples, but also the denial of a distinction of interest between the poor and the rich. And what I have in mind here is a more Machiavellian view of the separation of power, one that arcs back to the role of the sacrosanct Roman tribune of the plebs, who could not be touched and therefore held a veto. This view of the separation of power embraces internal divisions to ensure that the executive or whoever holds power is not only tied by the law, but to ensure also that the interests of the poor, of the underrepresented, of the marginalized do not get subsumed in and abused by the supposed general interest of an inexistent united people. And so to tie in these two themes, I do think it could be interesting to think about ways to ensure the political empowerment of distinct groups, such as, for instance, in New Zealand, where seats have been reserved for the Maori as representatives. So this would be a way of connecting these two themes of representing groups and of harnessing distrust that is already present.
Yeah, so I just want to say, I think this idea of deconstructing the myth of the claim by the executive to speak for all the people is so important. So it always has been a myth, right, that the executive has the ability and the power to speak for everyone. And so I think deconstructing it is such a crucial step towards figuring out what comes next. And I think if we see that they don't speak for everyone, then we would potentially weigh their power or their decisions differently. We might decide to treat their power differently, or cabinet in certain ways. I guess one thing I wanted to ask sort of in response is, like, I think we've seen some deconstructing of that myth, but on the wrong kind of path. Like, rather than talking about, as you mentioned, the disenfranchisement of indigenous peoples or issues like that speak to the executive not speaking for all, I think instead we've seen it follow that partisan path that we've been seeing, right? Where the idea is the executive doesn't speak for me because he's not of my party. So that way of saying the executive doesn't speak for everyone doesn't seem as productive.
Hi, Anne. Great themes, and it's got my mind kind of thinking about a couple of things. And the first thing I would ask is, if you could maybe elaborate on what you mean by harnessing distrust. What would that actually kind of look like in practice? And I'm wondering about the implications of if I understand the word of harnessing, maybe I've misunderstood it, but the idea of harnessing distrust and what effects that might have on, say, deliberative democratic ideals of consensus building, achieving compromise. What happens if you harness distrust? Are these two things mutually exclusive? Are they compatible? And maybe if you could perhaps elaborate on this fascinating idea about harnessing distrust. And thinking about the critique, and quite right critique about this idea, the myth of the unified, undifferentiated people. It kind of brings to mind, and I think this is a question that for me is kind of going, it's right under the surface of all the points that are being made kind of right here, is that we all have some idea of a change that we would like to see, or various kinds of changes we'd like to see. And I'm thinking more about the potential for actually important institutional change, not just in the United States, but across democracies. And I'm sorry, as the comparative is here, I'm the wet blanket on the discussion or something like that. But that's the thing that I'm thinking is really, I guess my question is, in the United States, what is it gonna take to have substantive institutional change to achieve some of the ideals that we're talking about? So I guess in a nutshell, is if Jan, if maybe you could elaborate on what harnessing distrust means and its compatibility or incompatibility with other kind of democratic ideals. And if anybody wants to talk about what is it going to take for institutional change, I'd like to hear about that too.
So I don't think it's a novel idea. I think that's actually what. So when Professor Levy presented his talk, he referred to the Romans, who by accident fell into the proper separation of power. Because their institutions, through accidents of history, ended up harnessing the existing distrust between the plebs and the nobles and the patricians. Yes, I was looking for the word. Between the patricians and the plebs. And when one way of understanding the English constitutions is also of these various houses being motivated by an existing distrust of the other group, or by their own interest or their own class interest, or however you want to frame it. But it's not creating an institutions that is meant to motivate resistance to the other institution. It's relying on an existing virtue or passion that is present. And that's the difference, I think, between the idea that our institutions can create a pride of office, which will motivate a need to keep the other branches in check. It's relying, there's no underlying virtue or passion that is moving it. And so I'm not exactly sure what are the passions that are moving us now, but what I'm saying is that if there was a closer relationship between these institutions and existing passions, that would be one way of motivating this resistance to the abuse of power. And that's why I point to the cities, because there is a strong political division, as we notice in the ways in which cities vote and rural areas vote. Yet this doesn't translate very much in the ways in which our representative institutions are thought. And that's generally because we think of a single polity that is being represented. And so there's a difference in terms of numbers, but not in terms of ways in which the power is divided.
This is such a fascinating set of themes. My imagination is captured by this idea of how we can disaggregate the demos, or kind of break down this idea of the unified people. And one thing it reminds me of is my own experience with what I think we might call left-wing populism in a Canadian context, where there is a populist element to a lot of the protest activity that we see these days, in the sense that there's an anti-institutional and anti-elite bent. But at least in left-wing populist circles, it seems to me that there's a profound commitment to intersectionality. There's a kind of people versus the elite, but there's a commitment to disaggregating the people in a way that really prevents the emergence of a unified representative to speak on their behalf. And it gives rise to a dynamic that's less about self-interested parties checking one another's power and more about solidaristic bounds. People are supporting one another and empowering one another because there's a recognition that it's in my self-interest for all my fellow citizens to be maximally free and maximally empowered. And so the kind of opening that you've left us with had me thinking about the differences between right and left populism and what different implications those might have for the separation of powers and the rule of law.
Just a little bit on Jan's big themes and to say things that I think he already knows, but for the sake of the audience, I am in overwhelming agreement with the direction that Jan wants to push this thought in. And indeed, those other ways of disaggregating the capital P people and trying to build our attachments to other subnational, sub-state identities to channel them and harness them into politically productive constitutional instructions. That is kind of what I've done for a living for some 20 years before reaching the Separation of Powers project, in particular with respect to federalism and decentralization. And I think it's an important and underappreciated truth about decentralization and federalism that aligning it at least some of the time with strong attachments tends to help stabilize the amount of decentralization and tends to help a system resist over centralization. That is to say, the existence of, for example, a Quebec tends toward the stabilization of Canadian federalism. Whereas in the US, which deliberately sought to prevent the emergence of any state in the Federation that had an ethno-national or cultural identity that was at any strong variance with the majority population, such that Oklahoma and Hawaii, for example, don't become states until such time as they have white majorities. That has meant that the states don't have that same kind of strong, independent social grounding in their attachments and their loyalties. And that's been one of the factors. Not the only factor, but one of the factors in the increased centralization and increased undermining of American federalism and decentralization. Finding ways to do that with respect to cities, which Jan mentioned, I think is something that's tremendously important. It's that interest of mine actually that brought me to this way of thinking about the separation of powers. I think it's an important theme all through Montesquieu, not just in the separation of powers material. It's an important theme all through Montesquieu that you get stabilized constitutionalism by building on these underlying pluralistic attachments. And so from a prior interest in things like multiculturalism and multinational federalism and decentralization, I get to Montesquieu, and then I notice the way in which that dynamic plays out in Montesquieu for separation of powers too. So I very much welcome Jan drawing explicit attention to those links.
I'd like to follow up on that if possible. And Professor Levy, from what I understand, your point is the idea is that maybe the United States should become a little bit more like Canada in the sense of decentralization and recognition of its, what we would call maybe in Canada, it's multinational or multicultural, or it's pluralist kind of identity. And I'm just wondering if you know as you say, Canada has Quebec, and say if the but Quebec identity is a cultural identity, it's a linguistic identity, and I'm wondering what would a Quebec in the United States kind of look like in that context, where the ways in which identity is constructed is different than in Canada, and where Canadians are now, and Canadian scholarship is now kind of discovering race and having its race enter the discourse, and rightfully so, challenging kind of our notions of culture. But how would this kind of play out in a context where identity is rooted in kind of different concepts? I see this as potentially problematic in the United States.
I think you're right. I don't think that there's anything about the federalism lesson that I just mentioned that is easily portable to the United States as currently organized. You can't create a Catalonia or a Quebec or a Bavaria out of the current map of American federalism. It's not there, and you can't just pretend it to be there. In addition, Quebec or Catalonia or Bavaria have the weight that they have, partly because there are so relatively few provinces in those federations compared to 50. 50 is a very hard number in terms of creating a collective action problem among the states. So even if Hawaii had retained a native Hawaiian majority population, Hawaii wouldn't have the weight in the American Federation that Quebec or Catalonia or Bavaria has. And you can't just institutionalize race in the United States, which I think is where you were looking at it with at least one eye. The reasons for having guaranteed Maori seats in New Zealand apply in some respects to both American Indians and African Americans, and arguably to at least some Latino populations. And yet, the social context about the institutional meaning of official racial designations in the United States is radically different. American Indian, like Maori, can be used as a political designation and should be understood as a primarily political designation, not a racial designation. But it's tremendously important if you want appropriate pluralistic recognition of difference and of different interests and different claims of justice in the American democracy, for there to be recognition of African Americans. And African American is not a political identity. And to create racial distinctions in the allocation of seats in some overt way, that wouldn't be productive in the American setting. So ways to channel African American political energy and voice around claims for racial justice can't be through federalism. It's not going to be through creating a black state within the American Federation, and can't really be through guaranteed legislative representation, as in the New Zealand case. It's one of the most critically important ways to try to align identity-based attachments with claims of justice, but it's institutionally tremendously difficult. And I don't have an answer sitting in my pocket about how to do it.
I appreciate that answer very much. And maybe in the interest of time, we should transition to our last set of themes so that we'll have a chance to take just a few questions from the audience at the end. But thanks so much for these themes and the discussion they prompted, Jan. That was really rich.
That's me now. I just wanted to very quickly thank the Center for inviting me to participate, and for Professor Levy for such a rich genealogical and pithy history of the concepts, and also to acknowledge that I am an uninvited guest on Treaty 6 territory, as well as a settler on Coast Salish unceded territories. I conceive of myself as a treaty person, being mindful of all the responsibilities for relationships in Canada that entails. So my questions, I'm going to change my second theme just a little bit, because I think parts of it we've already actually talked about quite a bit. And the first is sort of riffing off of one of Jacob's sentences in his talk, which is to mix is not to separate. And I am pondering, can we bring the mixed constitution back into our jurisprudence? And I'm asking this for a variety of reasons, partly going through the history that has been so carefully traced. And I thought I would start by just saying that there are basically three propositions in our jurisprudence that the separation of powers stands for. And the first is it's not strict, it's not watertight, it's not bright line the way it's understood in other jurisdictions. So we don't have a general separation of powers doctrine at all, really, in our jurisprudence. And I guess that's where I was thinking about the courts as a site of construction. Is that something we might want them to better articulate, to work on? Would that be helpful? Would there be risks? Of course, there are many concepts that the courts haven't really pronounced very much on. The principle of democracy, as Hillary would know, the principle of the rule of law hasn't been fleshed out fully, if it ever would ever be. But that's one question about, here's this distinct institution with a distinctive role where it can actually deliberate and provide more content to this rather sparse doctrine in our jurisprudence. And would that be helpful? We know that one of their strongest lines of jurisprudence, which firmly connects up with Professor Levy's talk, is in the idea that the judiciary is crucial to our constitutional order. The idea of judicial independence tied to the separation of powers coming out of our 1867 Constitution as a defining feature of our constitutional order, and also is what helps protect what the courts call the normative ordering of our Canadian legal system. And so that's very firmly in place, and that's the most articulated, or probably the best articulated aspect of the doctrine. And the third is, again, ours is not a transplant. The Canadian version of the separation of powers acknowledges the overlapping functions in a Westminster system, does not think that's necessarily illegitimate, although it may become illegitimate in certain circumstances, depending on the risks that arise around offices like, as Professor Levy points out, the Attorney General, which is definitely an office ripe for reform in Canada. So we don't have a political questions doctrine. We mostly deal with these sorts of issues through something like a doctrine of justiciability, for example. And that the most recent articulation of the separation of powers in our jurisprudence is through its connection with Section 1 in the Charter. And so our separation of powers doctrine is linked to the demand that legislatures demonstrate that they have thought carefully about infringements on rights and justify them. And so that our separation of powers is linked to this kind of culture of justification that's emerging in Canadian public law. So it's not about brute checking. We're actually asking another institution to tell us why. And that's a very important development, I think, linked within the separation. Maybe each branch should be able to have this practice of articulating the justifications for their exercises of power. It's also tied to judicial restraint and all that literature on judicial activism, obviously. Where it doesn't say very much is it says very little about the separation of powers in relation to the executive branch directly, oddly. It says very little about the separation of powers in relation to the administrative state directly. It says almost nothing about the relationship between the separation of powers and Indigenous peoples in Canada, which we know is a future large project. And there are some cases, but I'm going to go back to this. Well, what's there? We don't have checks and balances. So going back to Hillary, that's not part of our jurisprudence on the separation of powers usually, except in relation to Section 1 and Section 33. Those are our two identified mechanisms for checking in our separation of power order. We also don't talk about the mixed constitution. And so I guess I'd be interested in all of you thinking about this. I looked it up. There are lots of cases, and mixed constitution generally is in reference to things like bread and roll mixes and asphalt mixes, the constitution of various entities. They're not, so actually it's not there. But there is one case where the mixed constitution is mentioned, and that's the patriation reference. And I think that goes back somewhat to the beginning of a sense that it's a discussion about conventions, those other aspects of our constitution, the political constitution, how those have declined. And Jacob talks about this, the decline of ministerial responsibility, all of those conventions that are part of a parliamentary system are in trouble. And the quote that's used talks about things like the constituent parts of the state obliged to hold their public faith with each other. It's a quote from Sir William Holdsworth in the patriation reference. That all those who derive any serious interest under their engagements, as much as the whole state is bound to keep its faith with separate communities. And that is part of the spirit behind a variety of conventions, which we know were at play in the patriation reference. But that language has been animating all of our themes. And I'm thinking of that, here's this toehold. It's not there live, but it's possible we could attach that moving forward to some other way we could talk about the separation of powers in Canada, and whether that would be helpful in trying to get the judicial institution thinking about these problems. So I'm just opening that up to discussion. I can say the second theme, which I'm going to change a bit, because I was coming at it from, again, another legal perspective about this idea that if we want constrained executive power, we have to do more. And again, what's the role of the courts? And there's this very famous line from the Roncarelli case that in relation to the administrative state, there is no such thing as untrammeled discretionary power. And so if we were, again, harnessing that, scaling it up from administrative to higher executive, again, what is the role of the courts? For example, checking various kinds of executive power that we are normally, these courts are normally very suspicious or very tentative or very anxious. And maybe that's something, again, we need to think about. And that's tied to a certain kind of politics around, the suspicion and the anxiety is good. And coming out of a politics, I think, is consistent with Montesquieu around moderation and restraint. And those aren't really contemporary words. And so again, I wonder if that's just a pie in the sky kind of hope.
I'll just jump in. I really enjoyed those themes. I think it's a fantastic way to wrap up the discussion because it really kind of connects to a lot of the things we've already talked about. And I just wanted to pick up on one of the last things you said about the quote from Roncarelli about the idea of that there's no such thing as absolute and untrammeled discretion. And I think that's so interesting to think about sort of in terms of all branches. Like, on some deep level, we kind of have that commitment in terms of the exercise of any power, that there's some limit on how it's exercised, right? We don't think that judges can just flip a coin, and we don't think, so if a legislature, even though they have in some sense open power to enact whatever legislation they want, it's limited in some ways. And some of those are more overt and some are sort of deeper commitments. So there's constitutional checks on what they can and can't do, but there's also just a sense that they're accountable to those who elected them, and they should be trying to put in laws that follow that sort of the will of the people. And so I guess it just made me think about the role of constraint that you were talking about and who does the constraining, whether some of that is external constraint, like you were talking about with the judiciary checking the executive, but other ideas of constraint being partly internal and depending on a sense of your own role and a sense that certain things are out of bounds, and so sort of self-constraint.
I respond? I don't want to monopolize though, but I've been thinking about that too in relation to that other theme around the social classes and the status and the dignity that comes from being a member of a certain social class. And that was a protective and a function and a source of independence, at least as Professor Levy relates through Montesquieu's understanding of the mixed constitution. And again, it makes me think, so far the judiciary still has that attached to their office. They're very well regarded as a matter of honor. And we know that the judiciary is the most trusted institution in Canada, as it turns out, according to polling. But that other things have not. And so I guess one, to go back to our earlier discussion, the decline of any respect for politicians, members of parliament, that used to be thought to be an honorable function. And similarly with the civil service. And I noticed that with sort of younger generations. I grew up with the idea that the civil service, the idea that it was a branch that was an honorable branch, and that idea of loyalty to the crown and all that business, that's gone out the window. They're just bureaucrats now. There's no honor to being a civil servant, I think, in popular imagination. And so, yeah, there's something about the role morality and the status that I think is an interesting piece of the puzzle.
To go in a different direction, that was a rich comment, and there's so many things that we could talk about, but I want to jump on the mention of Indigenous peoples in Canada and thinking about the implementation of UNDRIP in the Canadian legal system and the possibility of moving towards free, prior, and informed consent for developments on Indigenous lands. And that sounds like an interesting, well, it's a veto if it's going to be properly implemented. And that would be a serious limitation on various policies, various actions of the federal government on Indigenous land in Canada. And I think that may connect with Arjun's question about the separation of power as a cause. How can we improve decision-making in Canada to ensure that it has, well, greater legitimacy or at least greater acceptance? Having something like free, prior, and informed consent is both a cause and a, I forget the other one, you used the cause and the
effect or outcome.
Yes, that's right. So it's both. Having something like free, prior, and informed consent, you can improve the political decision-making process, but you can also limit the interventions of the Crown on Indigenous land.
One of the cases I wanted to bring up, Jan, in relation to that was the Mikisew Cree First Nation case, where a number of First Nations were arguing that in the process of making legislation, there was a duty to consult that between the government and the affected First Nations before the legislation was enacted and run through the process. It was all in the context of an omnibus bill, which was really suboptimal. But anyway, and that of course failed. But there's such an interesting dissent by Madam Justices Abella and Martin on. They thought that the honor of the Crown and the principle of reconciliation meant that, yeah, maybe legislatures should be more constrained when they're enacting legislation, and at least in as much as it affects Indigenous peoples, maybe they should do a bit more consultation before tabling something in the House. That, of course, is a dissent.
This is a fascinating way to bring colonization and Indigenous jurisdiction into the discussion. I was thinking about this a lot myself. As I was listening to Professor Levy's talk, I was also working on a piece on treaties in Mi'kmaq. And I was thinking about the role of treaties as almost the original separation of powers in a settler colonial context, the original version of checks and balances, that they, in a sense, not only allocate jurisdictions, but also provide mechanisms for co-decision or mechanisms for co-contestation, at least, and how this often gets left out of our discussion of separation of powers and performs kind of a further erasure both of Indigenous people, but also of the constitutional status of those treaties.
I'm kind of temperamentally skeptical of things like consultation without express authority to refuse. And so consent rather than consult is the right kind of verb to my ear. But I want to mention in this context work by Jeremy Waldron, not himself an important advocate of Indigenous rights, a critic of lots of kinds of protections of Indigenous rights, but as a theorist of the rule of law, he has emphasized, rather than moments of refusal, the rule of law as having the ability to have one's say in court, to have the moment to be appropriately heard. And I think there is a way in which duties to consult and that construal of treaties and treaty rights would sit comfortably with that understanding of the rule of law, which he's done a lot to develop over the last 15 or so years, and which I'm not drawn to, but I think there's something to be said for, and it's something that I actually haven't properly taken into account in this separation of powers heavy version of what the rule of law looks like in institutional capacities. So if anyone in the audience is interested in the question, how to bring duties to consult into this conversation, I would say that's a place to look.
Well, I appreciate that opening, and I hate to truncate the discussion of these themes, but I did promise to save a few minutes for audience questions, so I'm going to make good on that promise. And in the interest of time, I'm going to do my best to creatively combine a couple of the questions and package them together. And I hope that the audience members who ask them will not think that I've done violence to their questions, but I've done my best to give them space in the time that we have. But there are three questions in particular which it occurs to me have a kind of similar nucleus to them. So I'm going to try and link them together. And the first expresses a concern for the increasingly technocratic, bureaucratic nature of governance and the perceived distance between the voting public and the actual administrative decisions which structure our lives. And there's a concern there that the increasing bureaucratization and increasing complexity of modern bureaucratic structures has effectively disempowered the legislature and through it the people, and that this is one possible driver of the polarization that is now threatening the separation of powers. And another question picked up on a similar point, talking about the role of party members within political parties. And the person who asked this question was feeling that ordinary party members have very little voice within party structures because they too have become bureaucratized in the same way that state formations have, such that there's a disempowerment not only of political parties in relation to the bureaucracy, but also citizens in relation to the parties of which they are members. And a third question expanded on that theme of disempowerment by talking about the role of globalization and the disempowerment of the national state in relation to transnational capital and the institutions of global governance. And I think what all three of these questions are getting at is the common theme of a disempowered populace, a populace that's less able to exercise meaningful control over the decisions that shape their lives. And the other theme that seemed to come through them to me is the question of to what extent is empowering citizens directly able to speak to the sorts of concerns that we've been discussing today. And I will open that up for anyone who would like to speak to it.
I have cranky views about all of this kind of thing. The complaints that parties are dominated by elites and are not truly responsive to party members. I mean, when Robert Michel in 1910 said, who says organization says hierarchy, as a way of speaking to people who were very surprised that even socialist political parties, which were devoted to the cause of human equality, turned out to have dominant political elites who actually ran the party. And Michel offered as an account of what parties as organizations just structurally were like, was that they were organizations and they had structures, and structures had hierarchies, and that those things were built in a way that was not susceptible to just ideological variations. So just because your political cause was equality didn't mean your party would be internally egalitarian. The idea of a golden age when the people actually authentically ruled, I think is a myth. I think it's a pernicious myth. I think it's one of the sources of populism as nostalgia. It stands in the way of seeing clearly the benefits and the costs of just the fact that politically we are always ruled. It is always the case that to live in a governed political institution is to have hierarchy and to have a separation between rulers and ruled. The best that can ever be said of that particular branch of nostalgia is that it's a way of saying, well, in my parents' or grandparents' day, people like them had a say, but the people like them was never the people. It was one slice of the people who had in that time and place some disproportionate voice. That's the closest that sentence can come to being true. But mostly there's not even that much truth to it. Mostly it's reconstructed memory. It's a way to complain, I don't see myself reflected in current policy. And I think the thought that one should see oneself reflected in current policy, that to be governed will be just an expression of the will of the people, has been a source of real confusion. And I argue in other parts of my work that it's something that is about as old as at least modern political thought. We find it all through social contract theory, not only in Rousseau, and that eventually becomes nationalism and populism in important ideologically distorting ways. That is to say, I don't think populism is a reaction to the change in history that says, in the old days, the people ruled and now the people don't rule and they're mad about it. Populism is rather the underlying ideology that generation after generation motivates this surprise. Hey, I think things and the government isn't doing the things that I think. And so I imagine that people like me all think the same things. And how come the government isn't doing the things that I think all the people like me think? Well, because that's not how government is. That's not how politics is. That's not what it's like to be ruled.
Unfortunately, colleagues, I have to leave a little bit early due to a scheduling error on my part. Just want to say thank you for letting me participate in this wonderful conversation. Thank you all, and to you and to all the audience members, wish a very good day and a good weekend.
Thanks, Arjun, and thanks, Jacob, for that very historically informed answer. I think that's a really useful perspective to have on the perceived feeling that I think is very real of disempowerment, that regardless of the validity of that feeling, it's at least not true that there was a time in the past when we could have expected better from the institutions that we live under. I think that's a really helpful perspective. Does anyone else want to weigh in on that question for a final word? Well, then maybe I'll put forward just one more before we close our discussion for the day. And this question is, given the sorts of crises that we're seeing south of the border in the United States in the separation of powers and the rule of law today, and the politicization of that court, and the hyperpolarization of those political parties, the question is, to what extent is this going to have an influence on our political culture and our conception of the separation of powers here in Canada, and what can we expect that to look like?
I guess I'll weigh in with the theme I raised, which was one way it would be for our courts to articulate, not in a thesis sense, but at least in some cases, how the concept, the doctrine of the separation of powers in Canada appears as a descriptive matter in the cases where it needs to be discussed, and setting out how, if there is indeed a Canadian model, and I hesitate to also suggest, if we pick up the idea of the mixed constitution, it seems to support constitutional practices that are embedded in the institutional dialogue metaphor that comes and goes. I hope it's coming back. That would be one way of at least saying that what we have here in Canada is not the same thing as in other jurisdictions, and in some ways that's where we don't want to go, where we've seen the United States go. And I admit my focus is narrow, and that's admittedly a very, very small piece of the puzzle, especially when phrased in terms of sort of disempowerment and disenfranchisement that the previous question was focused on.
I really appreciate that answer and appreciate the discussion in general. I do think we're about out of time, so I'd better call things to a close, but I'd just like to extend a very heartfelt thank you to Professor Levy for the talk that inspired this discussion. I really learned a lot engaging with it, and I'd really like to thank our panelists for coming together to take up the themes that talk raised. I think it's been a really rich experience, and I'd like to thank our audience for all of their questions and their engagement, and for showing up to pay attention to these issues. I think it's clear that our liberal democracies do face a number of important challenges, but I can think of no better way to protect our democratic norms and by gathering together like this to discuss the way that we govern ourselves collectively and to debate and exchange views about that. So I want to thank you all for being a part of that, and remind you that you will be prompted to fill out a feedback form when the session closes, and I encourage you to do that. But with that, thanks so much, and I hope you all have an enjoyable and safe weekend.